Hello, how are you members? I hope you're all doing great. My name is Conrad Mutiava, and today I'll be taking you through Introduction to Law, which is one of the fundamental topics of a student who is going to study law. So our topic today will be sources of law. Today we shall be looking at a topic known as sources of law. For purposes of following up on these videos, or in case you need an update, or in case you don't want to miss out on any video, please feel free to subscribe to my channel so that you can always have instant notifications of all the videos that I publish or release instantly. Also, in case of any comment, please do not forget to comment or ask a question in the comment section, and they will always be answered, or they are always appreciated. Thank you very much. So today we shall start with sources of law. Any student of law in their year one, or any person that is doing a diploma or a certificate, this is a very important topic for you to know. Sources of law are very important because they form the benchmark of where authority on legal matters emanates. So it's very important for a student to know what the sources of law are. From the onset, it's very important to first understand what is the definition of law. Before we go to look at sources of law, it's important for us to answer the question that what is law? There are so many definitions of law, so many of them, but the one that I will bench on today is the definition by Austin in Province of Jurisprudence, where Austin attempted to define law as rules of conduct imposed and enforced by the sovereign. So according to Austin, he says that these are rules of conduct that are imposed on two people by a sovereign power. So among those are the definitions of the sort of what amounts to law. Having known what a law is, then the second question is, where do these laws emanate from? What are the sources? Where do we get them? Where do they originate from? Ladies and gentlemen, the origin of law, the sources of law, are divided mainly into two categories. They are what we call primary sources of law, and then they are what we call secondary sources of law. For our first discussion, we are going to look at the primary sources of law. These are the most important from the source. Okay, these are extremely important. The first is the constitution of your country, or for purposes of Uganda, the 1995 constitution is the first and main principal source of law. Before you look anywhere else, you have to first look at the constitution of your country and see what does that constitution say about a certain principle, or what value does it establish. That is the first primary source of law. It's also important to note that the Constitution is the grand norm, okay, and it is the mother of all laws. And any other law, this is very important to note, any other law that is inconsistent with the Constitution of Uganda is null and void to the extent of its nullity. The explanation being that in case there is an act of parliament, in case there is a court decision, in case there is an act or omission by any person or authority that contravenes or that is not in line with the 1995 Constitution of Uganda, the same stands invalid, and it is null and void to the extent of its invalidity. This is a very important principle to appreciate and to pick from the very beginning in your law school. Ladies and gentlemen, I invite you to look at Article 2. Article 2, Clause 1 of the 1995 Constitution of Uganda is very authoritative. It's very authoritative, and it states that the Constitution is the supreme law, and any other law that is inconsistent with it is null and void. I also invite you to look at the case of Paul Kawanga Semogere and another versus Attorney General. That is case number 3 of 2000. Go and look at it. In that case, the Constitutional Court held that the Constitution is the supreme law of the land, and it has binding authority on all persons, and that any other law that is inconsistent with the Constitution is null and void, and that all other laws in the country and the Republic of Uganda derive their powers from the 1995 Constitution. That is a cardinal rule of law. It's important to note it. The second source of law, ladies and gentlemen, are acts of parliament. Acts of parliament. For example, the Contracts Act, the Penal Code Act, okay? The Access to Informations Act, among others. There are so many acts. All those acts are also a second, they are also a second source of law, okay? This is the second source of law, acts of parliament. And it's important that you appreciate them in that hierarchy, in that flow. Ladies and gentlemen, look at Article 79 of the 1995 Constitution of Uganda. From other countries, I'm sure, if you look down in your constitutions, you may find similar articles that provide for these principles because these are universal principles. So, ladies and gentlemen, for purposes of acts of parliament, in the Ugandan Constitution, look at Article 79, which gives Parliament mandate to make laws. Also look at Article 91 of the same Constitution, which provides for the procedures by which a bill becomes an act, and it's at the President's assent or on his third refusal, it automatically passes as law. That's very important to note. The power to make law was emphasized, has been emphasized by court. Look at the case of Maria Matembe and others versus the Attorney General. This is a case of 2000. Look at the law report of 2000 to 2005, volume 3, High Court Bulletin. Okay, this is introduction to law. So High Court Bulletin is abbreviated as HCB. Okay, that in full is High Court Bulletin. At a later topic, we shall also look at those various law reports and how they are abbreviated and how they are looked at in full. That is page 84. So in that case, ladies and gentlemen, where the petitioners challenged the Constitution Amendment Bill number 2 of 2005, which was also known as the Omnibus Bill. They challenged it in the Constitutional Court. Of course, in the judgment of court said and stated that the legislature must be left to perform its constitutional mandate, which is to make law, and that there should not be any undue interference from the courts as they derive their powers from Article 79 of the Constitution. Please go and appreciate those articles, read them in detail, and make sure that you understand them. Let's proceed to look at the third point on the primary sources of law, which is case law. Ladies and gentlemen, this is the most primary source of law after written law. Case law is very important. This case law is the body of decisions by courts of competent authority. So where a court of competent authority sits, it makes a judgment. That judgment is what we refer to as case law. Okay, it's very, very important, and it forms a source of law. It also forms a source of law. At all times, the decisions are treated with respect. Those decisions of court are treated with respect, and of course, courts must follow them. Okay, so if a decision is made by a higher court, then it has to be followed by a lower court. This is very important. The main purpose, okay, because we also have now to look at the main purpose. What is the main purpose of case law? Okay, the main purpose of case law, ladies and gentlemen, was held and stated by Judicial Master of Rolls in the case of Re Hallett, a case of 1880, volume 13, Chancery, page 712. Judicial stated, and quotations, the only use of case law is the establishment of some principle which the judge can use in deciding the cases or the case before him. So, Master of Rolls just stated what is the purpose of case law. The purpose is to establish a principle, okay, which the judge must use to decide or to make a judgment on the case before him. Again, ladies and gentlemen, I invite you to look at the case of Remo Richard versus Media Sub-County Local Government. This is a Ugandan case which you can easily access online. It's a civil appeal number 8 of 2014, judgment of Stephen Mubiru. Okay, is one of the prominent judges and you should always look out for his judgments. Justice Stephen Mubiru held in that case that whereas the highest court in the hierarchy has the liberty to depart from its earlier decisions. So it's important to note that in case the Supreme Court makes a decision, in one case it has powers or it has liberty, in another case to divert or to depart from its earlier judgment, which could actually even have similar facts. So Justice Stephen Mubiru was stating that whereas the highest court in the land has that liberty, okay, to depart from its previous judgments, he however went on to say that courts below do not have such liberty. They are bound to follow such decisions of higher courts unless they can be distinguished or found to be held per incuriam. Ladies and gentlemen, per incuriam, the term per incuriam means court had overlooked a statute or a certain principle of law. So ladies and gentlemen, when we say that the decision is per incuriam, here we mean to say that court made a judgment, but in making a judgment or a certain decision, it overlooked an existing statute or a previous decision. So food for thought or question for you, okay, and again you will be looking at this in legal methods. A question could be asked that under what circumstances can a court of law, okay, depart from a decision of a higher court? Let's assume it is the High Court of Uganda. It is making its judgment. Under what circumstances can a High Court of Uganda depart from a decision of the Court of Appeal? Okay, among others, there are mainly two circumstances. One, where the High Court or where a lower court is able to distinguish that decision of the Court of Appeal from the current case that it is handling. The other circumstance where it can divert, that is where that decision of the Court of Appeal was made per incuriam. And we say that per incuriam means that the decision was made in disregard of a certain act of parliament or a certain decision. So ladies and gentlemen, that is case law for you, which is our third source or third primary source of law. Let us proceed to look at customary law. Customary law is our fourth point, and it's also a primary source of law. I invite you to look at section 14, subsection 2, clause 2, okay, of the Judicature Act, and it states that insofar as written law does not extend any current custom or usage, the High Court can exercise its jurisdiction, and where common law conflicts with customary law shall prevail. So customary law prevails where there is a conflict, okay, between common law. That is very important to note. Go and read section 14, subsection 2, Roman numeral 2 of the Judicature Act. It will illustrate the principle that I just discussed with you. I also invite you to look at the case of Kabaka's government versus Musa Chitonto. This is a case of 1965, East Africa, page 278. This case, I open quotations, on the question whether common law prevails over customary law. That was the issue. That does common law prevail over customary law? That was one of the main issues for court's determination. And court vividly held that the fact that common law applies in Uganda only insofar as circumstances of Uganda and its people permit. Therefore, where common law conflicts, okay, where common law conflicts customary law, then customary law prevails. Okay, this is very, very important to note. Also go and look at section 10, clause 1, or subsection 1 of the Magistrate Courts Act, that is Cap 16, which provides that magistrate courts shall administer customary law prevailing in their areas of jurisdiction so far as applicable. So this section is also authoritative. It's also important at this stage to know what are some of the sources of customary law. What are some of the sources where customary law can be acquired? One is judicial notice. Now, what do we mean when we say judicial notice? When we say that a court has taken judicial notice, we mean that judicial notice is simply an instrument used by court to acknowledge a certain notorious custom or behavior. Okay, court can simply take judicial notice of it and say this is known. It is known, so there may not be any need to adduce evidence. So in law we say that court has taken judicial notice. Look at section 55 of the Evidence Act, that is cap 6, which clearly states that no fact for which the court take judicial notice need be proved. So this section is very clear. It says that in case court takes judicial notice of a certain fact, then there is no need to adduce evidence to prove the same. Why? Because it's very notorious, it's very famous, it's very known. So court probably does this for, among many reasons, to save time and to make sure that the case is handled in a very swift manner. The other source of customary law is expert evidence. Expert evidence is also used. Look at section 53 of the Evidence Act, which states that when court has to form an opinion on a point, the opinion of such a person, skilled, are relevant facts, and such people are called experts. So if court needs to make up its mind or to form an opinion on something, people that are experienced, okay, people that are skilled, professionals, okay, make relevant facts, and those relevant facts or opinions stated by them or the people that state them are what are known as experts. For example, an expert can be a doctor, can be an engineer, someone who has studied a certain field by way of profession. The other source of customary law are textbooks. Okay, look at the case of Njirwa versus Kagangama. That's the case of 1935, Uganda Law Reports, page 146. In that case, court relied, okay, on Roscoe's book for Banyankole customary law. So again, we are seeing this case is illustrating how courts in certain respects can rely on certain textbooks. But the textbooks must be those textbooks of prominent scholars, okay, respected scholars, not any handout or any small textbook. It has to be a book of a prominent scholar. The other source of customary law are witnesses. Witnesses can also be called, okay. Of course, the custom has to be proved by calling witnesses who are acquainted with the native customs. So such witnesses can be called, they give evidence before court, and then court can also use their testimonies or their statements as a source of customary law. The other source of customary law are what we call assessors. Okay, assessors contribute to the full understanding of these customs, and of course they form an opinion which is applicable to the cases at hand. Okay, so assessors are found in court, and they normally help in giving opinions, various opinions on cases that are before court. Of course, opinions of assessors as a principle of law are not binding on court, okay, but court can always rely on them when they are making judgment or for purposes of getting another opinion from other group of people. So let's proceed, ladies and gentlemen, to look at our fifth source of law. Remember, we are still looking at primary or principal sources of law. So the other point is equity, or the other source of law is equity. Equity is also a primary source of law. But what is equity? Equity is a body of rules of fairness, natural justice, good doing, and honesty. Okay, that is what we call equity. Okay, the development of equity and its application is to correct any injustice that is caused by common law, okay, or the strict application of law. So as you will learn later on, or as I will guide you, there are times where the application of law may create injustice. You see, the law is rigid, okay, it's straightforward, and there are no corners. So in such circumstances where what has been applied has been too strict or too rigid, equity comes in, okay, to make sure that certain injustices are corrected. So like we earlier said, equity is simply a body of law that looks at fairness, good dealing, honest transactions, okay, among others. So briefly, let's look at the maxims of equity, okay, so that you're a bit acquainted and knowledgeable. Of course, we shall have another tutorial sessions where we shall look at them in detail. But for now, look at those maxims of equity, which were clearly laid out in so many cases, but mainly Harrison versus Duke of Rutland, which is a case of 1893, volume 1, Queen's Bench. That is page 142 to page 149. These include, among others, that equity will not suffer wrong without a remedy. Okay, so this maxim simply is saying that in case there is a wrong, equity will always come in to rectify that wrong. Secondly, equity follows the law. So equity will never work in diversion or independently. It will always follow the position of the law, but it will only come in to correct the same. Thirdly, where there is equity, where there is equal equity, the law shall prevail. So in case there are two equal equities, okay, then the law takes over. Are we together? Third, number 4, where both equities are equal, the first in time prevails. So in case there is a circumstance where there are two different equities, okay, and all of them are equal, they all have a good reason, they are all right, then we shall resort to the principle of time. Which of the two equities came earlier or came faster? Then the other is he who seeks equity must do equity. So we are saying that in case you invoke the power of equity, you should also make sure that you do equity. Okay, don't come to ask for justice where you are also unjust. Okay, so when you come to justice, make sure that you come with an intention to also do justice. Then the other is he who comes to equity must come with clean hands. Okay, same thing again, we are saying if you come to justice, if you want honesty, if you want good dealings, then make sure that your hands are clean. Don't come to ask for justice whereas you're suppressing the other parties or your colleagues. Make sure that your hands are clean when you come to the temple of justice. Next is delay, defeat, equity. So this maxim is simply saying that in case you have a good cause, okay, in case you delay your good cause, then it defeats the righteousness for which you seek court to grant you. So make sure that whenever you have an issue or a case, even when you're right, make sure that you bring it to the attention of authority as early as possible. Next is equity looks at the substance rather than the form. So equity will look at the substance, okay, what is in the detail, rather than the nature in which it has come. Equity will not look at the form, okay, but it will look at the content. This is what this maxim in summary is stating. Next is that equity looks at that as done which ought to be done. So here we are saying that equity will presume something that is done which ought or which should have been done in the first place. The other one is that equality is equity. Okay, this is also a maxim of law. This mainly looks at equal distribution of property. Okay, equality is equity, that where there is equality, then there is equity. Next is that equity acts in the conscience, i.e. something on your mind. So equity works in the conscience. What is in your mind? It looks at the mind of the party. Next is that equity acts in personam. When we say that equity acts in personam, here we mean to say that equity will look at the person, at the individual person. Okay, it will intend to remedy the person that is hurt or that has been injustice has been reached out on them. I also invite you to look at section 14, subsection 4 of the Judicature Act, which states that common law and equity shall be administered concurrently, and where the two conflict on the same subject, equity prevails. So again, this section illustrates the importance of equity. Okay, that where there is a conflict, okay, between the two, then equity shall prevail. Let's now proceed to look at another source of law, and this is what we call international conventions and treaties. So international conventions, these are international agreements establishing mutual rights and obligations to the to the ratifying state. Okay, usually the head of state confirms an international treaty, and it's transferred to the domestic or municipal law of the country. So it's on an international level. If the head of state ratifies it, or the parliament of that country, then it is domesticated into the laws of that country. It is localized. Okay. Of course, in Uganda, look at the Ratification of Treaties Act under Cap 204. Cabinet is responsible for ratification of these international conventions or treaties. Apart from those that relate to armistice, neutrality, peace, and those that the Attorney General of Uganda has certified in writing that require a constitutional amendment. So these ones cannot be ratified just by those authorities. Such treaties can only be ratified by a resolution of Parliament. So there are some treaties where a resolution of Parliament is very, very important. Of course, there are a number of international treaties that have been a basis of our national law here in Uganda. There are so many, but among others, I invite you to look at the Wetlands Convention of 1971. Okay, that one was also domesticated, which formed the basis of the Wildlife Act of Uganda that we are using today. All these examples, if you're a student of law and you're answering your exam question, they are very important to include them because they can participate towards making sure that you get a good grade. Okay, the National Environmental Act of Uganda, okay, it also emanated from an international convention. International labor conventions also resulted into the basis of our Ugandan Employment Act and other related laws. So there are so many, but those are some of the 4 examples that I've been able to pick for you. Ladies and gentlemen, let's now proceed to look at the secondary sources of law. Okay, remember we have been looking at the primary sources, now we are looking at the secondary sources of law. Now, when we talk of secondary sources of law, what we mean is we are talking about subsidiary, or also known as delegated, or also known as subordinate legislation, or others also call it statutory instruments. These are very important sources of law, though they are secondary in nature, but court will rely on them, okay, to make certain judgments, or they are also another source where laws can be emanated or can be acquired. These secondary sources, ladies and gentlemen, it's important to note that they lay down the finer details which are not feasible. Okay, so those details of the law, you may read the Constitution and it is leaving gaps, okay, on what to do. But when you look at secondary sources of law, they will go into detail to make sure that they explain how certain principles are handled or how certain procedures are operated. Okay, so look at Article 79, Clause 2 of the Constitution, which gives Parliament power to delegate power to make law. So when you look at that article, it says that Parliament can allow other organs to make laws, and it is those other organs or bodies that make what we call secondary, subsidiary or delegated legislation or other laws. Okay, again, look at Section 14 of the Interpretation Act, which defines what a statutory instrument is. Okay, from the onset as a student of law, you have to know what is a statutory instrument. Okay, a statutory instrument, according to Section 14 of the Interpretation Act, is simply a document by which power to make law is exercised. Okay, also look at Section 16, because the other one was Section 14. So look at Section 16, which states that every statutory instrument must be published in the Uganda Gazette. So in case a statutory instrument is made, it has to be gazetted in the Uganda Gazette for it to have the necessary legal force. So let's look at some of the modes the types of making statutory instruments or other statutory instruments, which also form a source of law. Are we together? Among them includes ordinances. Okay, these are secondary sources of law. Ordinances, again, I invite you to look at Section 38, subsection 1 of the Local Governments Act of Uganda, which says that a district council has powers to make laws, not inconsistent with the Constitution. Again, you remember from the very beginning, we said that any other law that is made which is inconsistent with the Constitution is null and void to the extent of its inconsistency. Okay, and of course, Section 1 of that same Act defines what an ordinance is, and it is a law passed by the district council. So ordinances, these are laws passed by district councils. Okay, those councils that are headed by mayors and so on, district mayors. So what they pass are laws, and that is what we call ordinances. The other secondary source of law, ladies and gentlemen, is what we call bylaws. Again, I invite you to look at Section 39 of the Local Governments Act, which gives lower government councils of Uganda, EGI, such as the urban councils, the sub-county, division, village councils, powers to make law. Okay, so they have these village councils and urban councils, the LC3 chairpersons, they have that power in their council to pass certain bylaws, and bylaws also have binding force, and they are a source of law. Let's also look at another source of law, which are what we call directions. Okay, directions is a source of law. I invite you to look at Article 133, Clause 1B of the 1995 Constitution, which gives the Chief Justice power to make orders or directions to courts for the proper administration of courts and deliverance of justice. So the Chief Justice, as we have seen under that article, can also make law, okay, in form of directions. A direction is important for you as a student to know the definition. A direction is an instruction with the force of law on what to do. Okay, it's an instruction with the force of law on what to do. Examples of directions are many. For example, the practice direction number 1 of 2006. Okay, directing cases. This one was directing cases before the land tribunals to be heard by the chief magistrate court. So this is an example of such a direction. The other source also are what we call rules. Okay, look under Section 40 of the Judicature Act, which establishes the Rules Committee. Okay, Section 41 of that same act gives it power to make rules for the proper administration of courts of Uganda. Next are regulations. These are also a secondary source of law. These lay down matters of principle and are used for purposes of regulation and control. Next are books of authority, okay, or what others call opinion jurists, or books written by prominent scholars. Okay, there are so many textbooks that you should be reading by now as a student. Some of them are international, others are Ugandan, such books, but they should be books of only prominent scholars. In Uganda, we have so many respected prominent scholars. Among them is Professor Kanyeihamba, okay, who has written for you a book on constitutional history. There are so many professors. So Professor Bachibinga is also another one, Professor Oloka Onyango, and so many others. So such textbooks by those prominent writers in many respects can be used as a source of law. Even when courts are making judgments, they can always refer to them. Okay, ladies and gentlemen, that is the end of our topic today, which has been sources of law. Again, a recap is that you start by defining what law is. You look at the various sources of law, and remember we divided them into primary and secondary. Thank you very much for listening to me today. Please don't forget, in case you want to be up to date, to always receive these instant notifications of all these videos. Please make sure that you subscribe to this channel, and we shall be releasing videos as time goes by. Thank you very much, and God bless you.